the inconvenience caused. Thank you for joining us today, especially on a Friday afternoon. On behalf of the Society for Democratic Rights and the University of Cambridge, I warmly welcome you to the commemoration of 100 years of women in law. 2023 marked a significant milestone, the centenary of the Legal Practitioners' Women Act of 1923, which first granted women the right to practice law in British India. Today's event commemorates this centenary and celebrates the fearless, relentless and significant contributions of women to the Indian legal system. From Begum Quatsiya Aziz Razul, one of the founding mothers of our Indian Constitution, to Cordelia Sorabji, the first Indian woman to study law at Oxford. We've had the fortune of treading in ground-shifting and yet often unnoticed shoes. Today's event is to celebrate and mark their trails by reflecting not only on the past, but also focusing on the present and most importantly, the future of womening in the Indian legal profession. As the only man on the stage today, I demonstrate the space that men's voices have historically occupied within the Indian legal system and the disproportionate limelight that their contributions continue to receive. But to my left today, the panelists as well as the 3-minute film we are about to watch shortly, partly signify the present and the future of our profession, where a remarkably rare all-women panel sits to bring forth women voices who have managed to transcend the glass ceilings and who continue to uplift and support other voices, one hire, one case, one argument, one article, one poem, and sometimes even one film at a time. And finally, in front of me, some of you in the audience represent the work that remains to be done and the future that remains to be shaped. We will begin today with the keynote address from Honorable Justice Hima Kohli, who needs no introduction. Justice Hima Kohli is a former judge of the Supreme Court and former Chief Justice of the High Court of the State of Telangana and the Chancellor of the National Academy of Legal Studies and Research, Nalsa University of Law, Hyderabad. Justice Kohli's keynote address will be followed by a presentation of a 3-minute research-based film produced by Ms. Bhumika Billa, who is a legal academic, award-winning poet, and a Kathak dancer. She is a PhD student at the Faculty of Law, Cambridge Trust Scholar, and a research associate at the Center for Business Research, University of Cambridge. She reads, writes, teaches, and performs on issues of law, gender, as well as technology. The film will be followed by a panel discussion focused on the past, present, and the future of womening in the Indian legal profession. The discussion today will be moderated by Ms. Suhasini Haider, and we are grateful that she has recognized the importance of this event by taking time away from her demanding role as a diplomatic editor for the Hindu. Ms. Haider, who covers Indian diplomacy, international developments and conflicts, also contributes regularly to columns and hosts the weekly online show Worldview with Suhasini Haider. Joining Ms. Suhasini and Ms. Bhumika on the panel today will be Ms. Hima Kohli. Joining Ms. Suhasini and Ms. Bhumika on the panel today are Ms. Hima Kohli, Senior Advocate designated by the Supreme Court of India, who is recognized for her unwavering commitment to the profession, which has naturally carved out a space for women in law. Though she humbly refrains from calling herself a champion, her dedication to gender sensitization and equality speaks through her work. She has extensive experience in litigating matters like constitutional law, government tenders, criminal law, corporate law, and foreign exchange regulations. We also have on the panel today Ms. Jaina Tihari, Senior Advocate practicing at the Supreme Court of India. Her areas of work include constitutional law, gender equality, transgender rights, and disability law. She is also the Executive Director of the Center for Law and Policy Research and has written extensively on the need for intersectional perspectives in discussions on meaningful and systemic inclusion. And finally, we also have today Ms. Sanchita N, an advocate of record in the Supreme Court of India. She's been arguing cases in Delhi, Meghalaya, Karnataka and Kerala, and is the recipient of the Vice Chancellor's Award from the University of Essex. She is known for championing voices of disabled persons both within and outside courtrooms. It is now my utmost privilege to invite Honorable Justice Hima Kohli to the dais for a keynote address. Ma'am.
I'm glad it makes a lot of sense to come and speak about what we all gathered to speak about and not to go around in little circles. Makes a lot of sense. We are into business. A pleasure to see all of you. Many familiar faces, some not so familiar, but always a pleasure. Esteemed panelists, and should I name Viva, Jena, Sanchita, Bhumika, Suhasini, and of course my colleague Justice Shankar, who's in the audience, and this director back. We go a long way. It's been a wonderful journey, separate one for each of us, which is true, as we traverse our path with the judiciary. And now the intersections, we meet on an occasion of 100 years of women in law. We were assembled today to commemorate this significant milestone in the history of our nation. 100 years anniversary of women being granted right to practice in law. The moment serves not only as a celebration of the journey covered so far, but also a reminder of the untold struggles faced by countless women who have tirelessly fought for equality and justice within the traditionally male-dominated field. So, let's look at the historic backdrop. The struggle for women's rights in India has deep roots intertwined with the suffrage movement and the broader fight for independence of India from the colonial rule. It was in 1923 that India saw a landmark moment when women were allowed to enroll in law colleges. This was a radical shift at a time when the role of women was largely confined within the domestic sphere. The struggle that culminated in this landmark change for women is therefore worthy of celebration. Around the turn of the 20th century, the Legal Practitioners Act of 1879 and the Legal Practitioners Act of 1884 used to govern the appointment of lawyers. The Act of 79 brought about 6 grades of legal practitioners, and who were they? Advocates, solicitors, attorneys, vakils, pleaders, mukhtars, and revenue agents into one system under the jurisdiction of the High Courts. The Act of 84 allowed the High Court to make rules with the previous sanction of the provisional government relating to the qualifications and admissions of proper persons to be advocates. What is interesting is that though advocates and vakils were described as persons, women were not included in this definition. The case for seeking entry of women in the legal profession was made on the ground that women practitioners were needed to give legal advice to the Pardanishi women. However, the High Courts held that women were not entitled to be enrolled as vakils or pleaders in any subordinate court because of the same reason. Persons encompassed only men and not women. The legal profession as a male preserve was challenged in the year 1916 when Regina Guha, on obtaining a Bachelor of Law degree from Calcutta University, had submitted an application to be enrolled as a pleader in the Alipur District Court, and that application came to be rejected. The second challenge came from Sudhanshu Bala Hazara in 1921. However, by that time, in the very same year, Cornelia Shobraji became the first woman to be accepted as a pleader at the Allahabad High Court. The dual challenge ultimately led to the amendment of the Legal Practitioners Act, and then came about the Legal Practitioners Women Act, which was notified in 23. This act removed the ban of women from practicing law. Several countries were contemporaneously grappling with similar issues. For instance, in New Zealand became the first country to grant women right to vote in 1893, setting a precedent that would inspire suffrage movements worldwide. By the early 20th century, women in various nations began advocating their rights within the legal frameworks, highlighting the universal nature of the struggle. Some of the important Indian figures of the past century must be acknowledged for their contribution as prominent women lawyers, and I may just touch upon a few. Of course, we are all familiar with Cornelia Shobraji, who became the first woman to practice law in India, a notable figure in history. She was the first female graduate of Bombay University, first woman to study law at Oxford University, first woman to pass the BCL examination at Oxford in 1982, though she did not, mind you, she did not receive a degree from the university, because that is when that happened only after World War I. And despite facing significant obstacles, including being initially barred from full-time practice, her efforts laid the groundwork for the future generations of women lawyers. Another first woman judge, Justice Anna Chandy, that was in 1937. She made history as the first woman judge in India when she was appointed as a Munsif in Kerala. Her appointment marked a significant step in recognizing women's capabilities within the judiciary and set a precedent for future female judges. She was a well-known first-generation feminist of Kerala and championed the cause of women's rights in social, political and economic spheres, especially through a publication called Srimati, which was founded and edited by her. She went on to enter the male-dominated field of politics in 1931. At the core of her articulation of equality for women were the twin concepts of autonomy and dignity, almost 3/4 of a century ahead of the Supreme Court judgment in K.S. Puttaswamy. And that is how forward-looking she was. I now come to the first female Supreme Court judge, Justice Fatima Bibi, in 1989. She became the first woman to be appointed as a Supreme Court judge. She had started her career again in Kerala Subordinate Judicial Services in which year? 1958. She was promoted as a district and session judge in 1974. She was appointed as the first female judicial member of the Income Tax Appellate Tribunal and elevated to the High Court as the first female Muslim judge in 1983. She went on to be appointed as the first woman judge of Supreme Court of an Asian nation in 1989, and she served till 1992. Her time as a judge in the Supreme Court is remembered for her exemplary service to the cause of justice, her impartial adjudication, and warm relations with the bar. At the Supreme Court, she left a lasting impact on Indian law through several notable decisions. Similar is the journey of Justice Bhanupati, who started practice in 81, was appointed as a district judge in 88, elevated to the Madras High Court in 2003, and finally to the Supreme Court in 2014. Justice Leela Seth, we've all known her, met her, personally interacted with her, many of us. She was the first woman to be designated as a senior advocate by the Supreme Court in 77. She became the first woman to be appointed as a judge of the High Court of Delhi in 78. After serving as a judge in Delhi High Court, she became the first woman Chief Justice of the High Court, and when she took over the helms at the Himachal Pradesh High Court in 1991. That's where my brother comes from. We must acknowledge Justice Indu Malhotra, who also made history. as the first woman lawyer to be directly appointed to the Supreme Court of India from the bar in the year 2018. Now let's come to some global perspectives and figures of prominence globally. There are many important figures. Of course, time being short, I'm not going to judge all of them, but just about give you a flavor of them, who were accomplished professionals in or connected to the field of law. Charlotte Ray was the first black American female in US. She graduated from Harvard University School of Law in 1872, was the first female to be admitted to the District of Columbia Bar, and the first woman admitted to practice before the Supreme Court of the District of Columbia. This made her one of the first women of any race to practice law in that district. Eleanor Roosevelt, a first lady and a diplomat, she was a champion for women's rights and social justice, instrumental in drafting the Universal Declaration of Human Rights that was widely recognized as having inspired and paved the path for the adoption of more than 70 human rights treaties applied today on a permanent basis globally and regionally. In this backdrop, it is important to mention from India, Ansa Mehta, a female delegate to the United Nations Commission of Human Rights in the period of 1947 to 48, when we were in the throes of independence. She was a staunch fighter for women's rights in India and abroad. She is widely accredited for changing the phrase, all men are born equal and free, to all human beings are born free and equal, in Article 1 of the Universal Declaration of Human Rights. Anna Evans was the first woman to graduate with a Bachelor of Law degree from the Australian University in 1902 and finally admitted to practice in 1921 after a significant legal reforms took place. Helena Normative, one of the first women to practice law in the UK, became a barrister in 1922. She was a notable figure for being the first woman to obtain a divorce for a client, and for her role as the first female King's Counsel in 1949. That marked a significant milestone for women in the legal profession in Britain. Then comes, we cannot forget, Justice Sandra Day O'Connor's US Supreme Court judge, who was nominated to be the first woman judge on the country's highest court by the President, then Ronald Reagan, in 1981. She became the first woman to lead a state senate, the first woman to serve US Supreme Court, and the first woman to have her name attached to a law school. Justice Ruth Bader Ginsburg, a pivotal figure in advancing women's rights through her legal work. She co-founded the Women's Rights Project and ACLU, argued several landmark cases before the US Supreme Court, and became the second woman appointed to the US Supreme Court, where she continued to advocate for gender equality and civil rights throughout her tenure. Justice Mandisa Maya, appointed as South Africa's first female Chief Justice as the head of the Apex Constitutional Court this year in 24. She has been an influential figure in promoting justice and equality within the legal system in South Africa. Let's look at the challenges that have been faced by women. Globally, the progress has been rather uneven. While countries like Belgium and Canada boast of full legal equality for women, others are still grappling with systemic barriers that have hindered women's participation in the legal profession. According to World Bank report titled Women, Business and Law, as of 2023, only 14 countries have achieved full legal parity for women. I have recently come across an article which I wanted to share with you in the ABA Law Practice Journal of November 2023 edition. The title was Getting Beyond Bias in the Legal Profession, where the authors have described the dilemma that women practitioners face that has been described as the Goldilocks dilemma. If they conform to the dominant feminine stereotypes, that is, being warm, being pleasant, being modest, being deferential, being concerned, they are seen as too soft. They are seen as somebody who lacks fire in the belly. If they adopt a traditionally masculine behavior. They are perceived as too tough, unpleasant, and dominating. In other words, a woman faces a constant struggle to maintain a balanced approach in her profession. Women continue to face this challenge and have continued to do so even today. As of 2023, the data for 15 states provided by none other than the Bar Council of India indicates that there are 284,507 women lawyers. They account for only 15.31% of the totally enrolled 15,42,855 lawyers, while many dropping out due to lack or because of absence of work-life balance, because of systemic biases. The lack of representation at senior levels remains a pressing concern. Similarly, the statistics from the 2022 survey and research paper prepared by DNLU Maharashtra in respect of women in legal education paints a bleak picture. 5 out of 23, that is only 21.73% of the national law universities had females as vice chancellors. Only 27 out of 104 professors in NLUs were women. It comes to about 25.96%. 37 out of 91 associate professors, that is 40.65% of them were females in NLUs. Now we come to representation of women in the higher judiciary. That has not improved much, friends. As per the 21 study, out of 650 High Court judges in India today, only 76 are women. This amounts to about 11.7% of the current strength of the High Court judges. The position is better at the level of the district judiciaries, where in some states, women judicial officers account for almost 50% or a bit more than that of the strength. Notably, in the past 75 years, no woman lawyer has been appointed as an Attorney General for India, nor has a woman lawyer held the post of a Solicitor General of India, though the number of women holding the post of ASGs in Supreme Court has increased marginally. Women ASGs representing the union government in state high courts are few and far in between. What are the major reasons for the stultified progress of women in the profession? Historically and even in the present, major reasons that have stifled the participation and growth of women as lawyers can be identified as, and I'm not saying these are the only ones, there may be many others. Gender discrimination, gender bias, which was rampant from early days, has overtly subsided but continues to persist in surreptitious forms. Women lawyers have often encountered stereotypes that question their competence and their authority. The perception that women are less aggressive or authoritative compared to their male counterparts undermines their credibility in court. This bias has affected not only the hiring practices, but also limited the opportunities for advancement within the legal firms and the courts. Another issue, work-life balance challenges. The struggle to balance professional responsibilities with family obligations poses a significant challenge for women lawyers. Traditional gender roles often dictate that women should prioritize domestic duties over their career aspirations. The reasons are not far to see. Women are the primary caregivers of the elderly and the children at home. As a result, many women lawyers found it difficult to commit themselves fully to their legal careers, leading to a high attrition rate. The third issue, safety and infrastructure issues. Safety concerns plays a role in deterring women from pursuing litigation. Many female lawyers feel unsafe working late hours or traveling alone to court, which can limit their ability to take on any type of cases or engage fully in courtroom activities. Lack of basic infrastructure, something as basic as a restroom facility, further contributes to an unwelcoming environment for women in the legal settings. Fourth issue, lack of mentorship and network opportunities. The absence of mentorship and networking opportunities compounds these challenges. Women entering the legal profession often lack access to guidance from established lawyers, both men and women, who could help navigate the complexities of the male-dominated field. Entering a well-reputed law firm without any reference in itself is a big challenge for a newcomer in the profession. We now come to the global comparison. When we look beyond our borders, the story of women in law resonates worldwide. In countries like Canada and the US, women have made significant inroads in the legal profession. In Canada, women represent about 50% of law school graduates and hold prominent positions in the Supreme Court and the federal government. This progress is a testament to what can be achieved through concerted efforts for equality and inclusivity. Conversely, we should also see challenges that mirror our own. In many parts of the world, women are still struggling for basic rights to access education, let alone the right to practice law. This disparity underscores the importance of international solidarity and shared learning in the quest for gender justice. Establishment of organizations like the International Association of Women Judges, Women in Law International, All India Federation of Women Lawyers, Society of Indian Law Firms Lady Lawyers Group have fostered networks that support female lawyers and judges and promote gender diversity within the legal practice and the judiciary. But there's much more to be achieved. So what is the way forward? As we look ahead, several steps must be taken to further empower women in law, some of which I'm touching upon. Policy reforms. Advocating for laws that ensure equal pay and parental leave can help create an equitable environment. Currently, our parental leave laws are confined to maternity leave. However, there is no national law mandating paternity leave in the private sector. 2. Mentorship programs. Establishing mentorship initiatives can guide young female lawyers through their careers, impart skill development, give them ethical routines, build networks and connections, and familiarize them with the legal customs. Establishment of scholarships and funding for women pursuing law can further empower the next generation of the legal leaders. 3. Awareness campaigns. Increasing awareness about gender bias and discrimination can help foster a more inclusive culture within the legal fraternity and the legal institution. Gender bias, friends, can be explicit and implicit. Explicit is when there is discrimination in hiring and promotion patterns for women lawyers, underrepresentation of women in the field of prosecution and of senior lawyers and judges. Implicit bias can be gauged from slack enforcement of the existing laws, the existing rules and regulations that have been designed to prevent such bias. Deep-rooted or preconceived notions are a facet of implicit bias. What is important is to identify gender bias as an impediment to equality and progress. Lastly, global collaboration. Learning from the experiences of countries that have successfully navigated gender discrimination and implemented gender equality measures can provide valuable insights to other nations on the same trajectory. Non-marginalization of women-centric issues within the legal community is the first step to negotiate gender bias. So, as we commemorate this centenary milestone, it is imperative to stop and look back to realize how far have we come, and then look forward to assess how much further do we need to travel. The journey towards gender equality within the legal profession is an ongoing one. It requires collective efforts from all sections of the society, be it the government or the public sector, be it the educational institutions or the civil society, be it the private sector undertakings or the MSMEs, and above all, the family and the community, where a woman faces the first set of barriers. Judicial stereotyping must be addressed by sensitizing judges and legal professionals to recognize and overcome dormant biases. Anti-bias training programs, workshops, debates, and discussions, like the present one, are the need of the hour. They play a positive role in addressing gender bias and ensure that equal and fair treatment is extended to one and all. To sum up, friends, the future of women in law in India hinges on our collective effort to dismantle systemic barriers, and promote an environment that fosters equality. Initiatives aimed at mentorship, skill development, and creating inclusive workplaces are essential to ensure that women not only enter the legal profession, but they shine their light from within. We must advocate for policy changes that support work-life balance, such as flexible working hours, implementing parental leave besides maternity leave, as also harnessing technology to promote work from home, simplifying processes and creating a conducive working environment. We must allow women to excel in their personal and professional lives. The journey is far from over. I leave you with a statement made by Sheryl Sandberg, the American technologist, executive and philanthropist writer, who said, and I quote, "We need women at all levels, including the top, to change the dynamic, reshape the conversations, and to make sure that women's voices are heard, are heeded, not overlooked and ignored." Thank you for your day.
Thank you so much, ma'am, for such a promising and well-thought beginning, and especially for acknowledging names who we must celebrate and whose legacies we must commemorate, both in India and outside. So thank you so much. A very good afternoon, everyone. It is my pleasure to be here and to welcome you to our film launch and the panel discussion. The traditional blindfolded statue of Lady Justice holds the scale in one hand and the sword in the other. While the scale symbolizes balance and fairness, the sword represents power and punishment. In a very recent initiative by the Supreme Court, the blindfold was dispensed and the sword was replaced with the Constitution of India, symbolizing the open eyes of law that must see everyone equally. While there has been an opposition from the Supreme Court Bar Association against this alleged unilateral initiative, we are not here to discuss whether or not the new statue is better than the old one. As you will soon discover through my film, the recurring phrase that my poetic voice hooks on is, "Lady Justice might be blindfolded, but the men guarding her aren't." And that is one of the issues we hope to touch upon today. Aesthetics of law matter, and so does challenging the symbolic pretense of neutrality embedded within the black and white of our everyday lives. But the question must go beyond the statue of Lady Justice, to include the living, breathing voices of the ladies involved in this precarious system of justice. That is what this film and the phrase seeks to be a reminder of. The system is only a sum of its agents, and it's time we change the way we are acknowledged and treated at our workplaces, and perhaps more importantly, the way we are forgotten to be remembered in various accounts, books, biographies, and legacies of genius legal minds that this country has produced. At least I don't remember reading about a legal genius who was a woman in my law school. I dance in the film, embodying the emotion behind all the overlapping, tired and angry voices of my female research participants, who echo the same sentiment and who have all been repeatedly asking the same question: where are the women? And more importantly, where are the disabled women, the Dalit women, the trans women, the Muslim women, and the list continues. They are usually either invisible from positions of leadership. After Justice Hima Kohli's retirement, we are left with 2 women Supreme Court judges out of 33. Or they are hyper-visible in the physical spaces of legal work, constantly battling the male gaze, lack of well-functioning toilets, the pressure to wear saris and dress a certain way to be taken more seriously than their male colleagues, the precarity of employment contracts, unstructured times of legal work that makes it impossible to reach home safe, and sometimes even explicit abuse and harassment at our workplaces. While Kashish and Justice Kohli reminded us of the legacies that have given us something to celebrate this past 100 years, of women in law today, the film is a reminder what our present, unfortunately, still looks like for most of the women sitting on the benches, practicing in courtrooms, interning in litigation chambers, arguing in legislative bodies, advocating with communities, clerking with judges, and researching in law schools. The film presents original evidence of the epistemic injustice women face in their mundane day-to-day lives and brings together dance, poetry, music, and color to bring the statue of Lady Justice to life. I hope you enjoy watching it.
So I think gender and identity have really strong roles to play in how people are navigating these spaces. Don't wear anything that reveals, any hint of cleavage is bad, tie your hair, don't wear any shiny earrings.
Where my clothes used to get scrutinized like every day, then this other time somebody was literally falling on me. You know, it is so normalized, especially when it's a senior, hugging and calling us darlings.
I feel unsafe walking into the office. To me, it seemed like anything could happen and I would have no recourse, and I am going into it on my own.
Don't wear anything that reveals your thick skin, the courage beneath, your hair strands, the genius they keep, your red lips, the dissent concealed. Lady Justice might be blindfolded, but the men guarding her aren't. And boy, they love to see their counterparts in saris.
I made a decision to switch to saris, and it's made such a huge difference.
So the senior is like you're looking great with the sari, but you should remember that when you are wearing a sari, you should have time, abundance of time in your hands so that you can walk with grace.
You are deserving only if you wrap your bodies in pallus of humility and tuck your tongues beneath the pleats of grace, spinning on the wheel of a gaze that defines the lines of dignity and merit.
This fear, like, will I be able to make something in my career? Because clients have this thing, they see you 80-90% of the time, they'd rather go to a main
actually in positions of power are appointing judges to keep saying we should be doing it in a speech. So much of it is a lip service.
Spinning on the wheel of a voice that twists the lines to tell our stories.
For example, in the hijab case, the cases were all filed by lawyers. Petitioners have not actually come and discussed with the lawyers that this is what I'm facing.
Lady Justice might be blindfolded, but the men guarding her aren't. They can see how you fit your saris, your hijabs, your lipsticks, your bras. Well, it's time we stop spinning. It's time we turn the wheels into rungs.
You know what's a counter word for that? So I said, okay, I'm calling it sisternity. We have been trained not to support each other, which I feel that women never meant to.
Women argue in court, I almost have like this little bit of anxiety. It's like each woman carries a burden of not just her own ability, but also of representing all women.
It's time we stretch the lines and make space for ourselves in our story.
Yeah, thank you so much. Is it even a complete event without a technical glitch? I would now like to invite our panelists to have a discussion, and if any of you would like to record your initial reactions to the film, please feel free to scan the QR code for a 1-minute quick feedback, and also if there are hard copies of the forms lying around, so if you would like to just record your initial reactions. Thank you so much. Over to the panel.
Thank you. I have a question. Only we can scan it. We can just speak it out. Like what you guys say. You can fill it out. There's only a form.
Thank you.
Thank you, Bhumika, for really setting the stage, and thank you, Justice Kohli, for really putting out such a comprehensive view of what women have not only had in terms of their history, but where the next 100 years can really go. And I want to come to Bhumika in just a bit to talk about the film as well. I have to make a confession. I'm a journalist. I'm probably the only journalist in the room. And I really dread March the 10th. As you know, that's UN Women's Day. And the reason I dread it is because I'm always asked to come on and speak about women's causes, women's rights, how far have we come, where are the problems, what are the challenges. And there are always these lovely panels. And I always say to them, but tell me who's going to be in the audience. Because I don't want to be the woman talking about the problems women face and the rights they need and the challenges they have to an audience of women. And so I have to say it's a credit to you, to both our organizers, the University of Cambridge and the Society for Democratic Rights, and all of you as a legal community, as a legal profession, who have come together, and there's complete, I think, gender parity in the audience over here. So one round of applause for the audience to start with. You know, we often hear about the causes that the legal community take up. We often hear, good evening, ma'am, and welcome also. We also hear about the kind of fights for gender justice, for transgender justice, for disability justice, for same-sex justice, and all of those that are fought essentially by lawyers. When we watch our television screens, you always have lawyers fighting for causes. We don't hear as much about what the lawyers themselves go through and what happens at the bar and at the bench. So if I may start, Justice Kohli, by asking you that question. What has your experience been in terms of navigating your way from bar to bench, and where do you think you've faced the most personal challenges?
Good evening again. And as she was saying so Hasni, it's nice to see men. I've got my colleague Justice Rishikesh Roy here, so kindly come. And besides Justice Chakdar, we have Justice Jasmeet Singh and Pratibha Ji both here. And this is what brings them to this cause, and we must admire the fact that they've taken up time to be here for the cause. They want to be here as an audience to see how we all respond to things which we've all been through at some stage or the other. So it's not that when you navigate your way around, speaking for myself as a lawyer, initially the challenge was more to make oneself visible in court. The challenges were not just that there were men around you, the challenge was that the clients were also men. And those men were the ones who would translate into work for you, and you didn't know how to navigate your path. Those were challenges which came naturally to most of us. I think what I'm saying would resonate with many of the women here and beyond. That to be able to get a client and retain a client, and I'm talking of mid-80s, when most of them were men and there were very few women who would come to court, and those who came were primarily in the family court section of litigation. In commercial litigation, which was, or property litigation, or any civil litigation, which was my forte, it was never easy to be able to connect with private clients. The initial journey would be easier for women only because they thought that it would be appropriate to come on a panel and of any government or non-government agency where you would get regular work for not the money, but to be seen. The fee aspect was of least consideration initially, because it was more the importance of getting a matter, being able to make a mark in court, and being able to demonstrate your merits. That was the path that one had to negotiate through. As judges, when you move on to the other side, again, the challenge is just as much to be able to prove yourself equal to your male colleagues in many facets, which are taken for granted that perhaps the men would do it better many times, or certain jurisdictions would come more easy to some of your male colleagues vis-a-vis the women colleagues. Maybe because those who assigned the roster thought that women would be more effective in particular jurisdictions. Not necessarily as a bias, but a natural reaction, I would say. I'm not blaming anybody, but that was the time when that happened. It's not happening now. I'm happy to note that we have, in many of our high courts, women who are handling commercial matters, IPR, all of it, tax, service, what have you, not just confined to family courts or women-centric issues, no. So that's the way forward, and I think we've come a long way from where we started.
That's certainly heartening to hear. You know, the question about you being one of 3 out of 33 on the bench. How do you think we should tackle the idea of representation? Is it necessary to sort of have, you know, enforced numbers, enforced quotas, to be able to see more women there?
I think Jenna and I had a conversation on this side the other day on VC on this or the other issue. I don't think that there should be any compromise on merits. No. I think that women are good and they should prove their worth. And they don't want these concessions, mind you. I've not come across women who are saying, give us a quota because we are women. Not at all. They want to be recognized and considered at par with their male colleagues, whether as lawyers or as judges, and get their due. So that's it. No more, no less. That's what they want.
If I could also just ask you, and then I'm going to come and bring all our panelists into the discussion, how much is being a woman and having your information and your experiences sort of inform your own judgment when it comes to cases that particularly affect women? You know, there was so much in the news about the abortion case, for example. How much do your experiences as a woman inform perhaps your idea of the judgment?
You can't detach your gender from your judgeship. If you're a man, you're a male judge. If you're a female, you're a female judge. But end of the day, what are you? You're a judge. And what are you governed by? Not just by your experiences that mold you, but also by the law that governs the field. So it's a quite straight jacket. There are mentally no challenges. In fact, I think it adds to your persona as a woman because you have got all that experience with you. You don't need to feel sorry about it or brush it under the carpet. If you're a woman, well, very good, then just look like one and behave like one and get on with it. So, as that documentary was mentioning in one of the phases of a red lipstick, well, here I am. And I don't make any bones about it. And I don't think any colleague of mine anywhere made any bones about it. They will be happily they're accepting us for what we are. Sometimes we are conscious. We may be conscious, our colleagues may not be so conscious about this. We need to navigate around our own feminism too. And then, when we are on the dais, the point is doing justice on the given facts of the case. Whether it could be a case of this nature, MTP, or it could be another case relating to sexual harassment at workplace. Sometimes men are more empathetic. They have more sensitivity on issues like that, and I've noticed it with my colleagues, than perhaps even a woman, because you just take those things for granted. So you kind of harden up and build it up, whereas men are more sympathetic. So I give full marks to my male colleagues on many occasions who gave an angle to it.
I'd really like to come back to you on some of the aspects of how the law has progressed in terms of women's rights over the last century. But I want to bring in our young filmmaker and legal expert, Bhumika. And to start with, Bhumika, I'm looking at this. It's an intensely personal video. It's an intensely personal film. And I'm thinking of why we're all together over here 100 years since the passing of the Legal Practitioners Act. And the life of Cornelia Sorabji, in a sense, which is just fascinating, because when you look at her, she's known for so many things, and Justice Kohli really put it out for you. She was a first in so many ways, and yet her own professional success was always dimmed by her gender. And at the end of her life, in fact, her biographer writes, was her life really a success? Because while she was repeatedly disallowed from actually appearing, or practicing. She was made an advisor to the Court of Wards because her big cause was, of course, the Pardhanasheen women of the time. And she was made an advisor to the Court of Wards, but she wasn't really allowed to actually argue or pass any judgments. But it was her guide on Pardhanasheens that became the kind of unofficial, unwritten law and protocol for the government to move ahead with. And yet this was a woman who had to even fight for library access, to be able to read beyond the hours that were set out for her as a woman. When you look at that 100 years ago, and you look at what you are portraying in this film, do you think we've come a long way?
Thank you so much for that very interesting, you've almost captured everything in the question itself. I mean, we have come a long way in terms of acknowledging the systemic challenges that women face, but we are, I think, far away from actually addressing them. And regarding Cornelia Sorabji, I think there's always a cost of being the first, and I think she paid that cost to a great extent, and so have many women historically all over the world. And I think in the narratives of how there's sort of a culture of hero worshipping almost in the legal profession. And while all those lawyers are really inspiring and their stories are really moving, and the cases they've handled and the legacies they've left are worth of remembering, I feel that I've never seen a woman being written about in various anthologies of biographies. There's books, Legals and Quoting Politics, and all these books have written and acknowledged the legacies of the top 10 or the top 12 or the top 8 lawyers that India has historically seen, and women are still absent. And while 100 years ago there were protests happening in Oxbridge against the right of women to get degrees, even when they were allowed to sit in the classrooms, they were denied the degrees, and men in Oxbridge came out on the streets protesting against that, and they said merit is dead. While that was still happening, I think today, at least the optics of it has changed, but I think there's a lot more work to be done based on my research.
Certainly, and at least one thing has changed in 100 years. Everyone on this panel is a woman. And you know, it's interesting, you were talking about the hero worshipping that happens of senior lawyers, and Cornelia Sorabji herself had 2 relationships, inappropriate, with her seniors, and the brunt of those relationships was really borne by her career. One of them was with somebody who was representing the government, and you see that becomes a kind of, you know, almost a sort of a telling commentary on some of the aspects of the legal profession. If I may ask you, so there's all this talk about, and the movie talks about it, Justice Kohli talked about the fact that, you know, women don't necessarily stand up for other women, that you're expected to be a certain way, you're expected to, you know, the Goldilocks principle, for example, don't be too soft or you won't be taken seriously, don't be too hard or, you know, you'll be seen as threatening. Where is the whole concept of a sisterhood or sisternity, I think you call it, and you know, the women's hour really goes?
This is something that, in my experience, I have been experiencing. And more so after designation, because till the time you get designated, you are in a space where you are performing jobs for other people. This is a space where you have to establish your own identity at a particular space. So you are admitted into the room. Now, in that room, do you stand while others sit? Do you sit at the table? Do you sit at the head of the table? Do you sit at the foot of the table? And how are the people who are assisting you looking at you? So what I found in my journey is that when I got designated, not many women briefed me. Even now I can say, and this will be quite surprising for everyone, that my majority of briefing comes from men. So that set me thinking that why is this happening? Why is, and we have very, very vibrant young women as young lawyers. And that thought process brought me to a conclusion that over centuries, ages, women are socially and mentally trained to appease men. And we get a better sense of satisfaction if we are appreciated by men rather than by women ourselves. So what happens is that it's like a catch-22 situation, that you'd much rather be mentored by male colleagues, you'd much rather be appreciated by them, and the woman is being seen as a woman both by the woman and the man. So the thing is that your efficiency or your competency really is like the first blush is your gender, and then your competency walks in.
Interesting, and I hope all the men in the audience are taking notes about really how it is also the women who put the same kind of gaze on women.
Yeah, so I don't have any intellectual basis for it. I don't have any theoretical basis for it. It's just an experience.
No, sure. And thank you for sharing that. Jenna, if I could ask you, there's one more step in invisibility. You've worked so hard for transgender rights as well. Give me a sense of how you see navigating this idea of, in one sense, putting your identity aside. As Justice Kohli said, merit should be the only way forward. And yet there are so many categories in society that don't have the ability to be a step upward. You are at the same equal level with all others. How does one navigate that?
Thanks for that. I would go with what Justice Kohli said, that yes, in a way, merit and your work should be the only thing that matters in court if you're a lawyer. But at the same time, we do carry our identities with us. Whatever your identity may be, you may be man, woman, transgender, Muslim, Dalit, whatever. But your work should matter. And the challenge, I think, for many persons, women, trans persons, extremely difficult, because today in India we have, I think, just 3 or 4 trans persons who've enrolled as lawyers. Their biggest challenge is actually even getting enrolled with the Bar Council. With their hurdles of name and gender change. We had to file a case, I had to file a case in the Karnataka High Court for one trans woman lawyer who was not able to get enrolled. So those are the initial challenges which they are now facing, which women faced earlier, to just get the right to practice. And then I think history will repeat the same thing. Do courts, do lawyers, do judges, do clients accept them for their work and merit and can look past their gender identity? After all, most of them are saying, we just want to practice law. We want to be lawyers. And that's what women started saying. We just want to be lawyers and be taken for our work. And so those challenges are far more multiplied when it comes to further minority identities.
Very interesting. And of course, Sanchita, you've looked at this invisibility question from a different lens. I'd really like you to talk a little bit about your personal experience on any of these issues that we've just discussed, but also particularly when it comes to trying to become a more inclusive community and inclusive profession.
I'll start with an experience when I was doing LLM in University of Essex. One of my professors, who was the ex-special rapporteur on Right to Health and then
CAPG, Human Rights Commission of New Zealand, he wanted to hire me as his research assistant. Now this was a phase when I visibly looked very sick. I was very sick. And I have a neurological condition, okay? So at that time it used to affect my daily activities to a greater extent. And it was affecting my studies, everything, in short. So I wondered, why would anyone hire me? I myself. So I asked him this question, that why would you hire me? I said that if you have a person who has the same competence as I do, that much I knew, that he was impressed reading my research essay, and therefore he wanted to hire me. I said, if you have someone with an equal competence, and you have someone with a disorder which is likely to affect your work, who would you hire? He said, you know what, if you ask me to keep the law aside, I'd rather hire the person who has it, simply because I want to break the paradigm. So to the extent a person with disability is concerned, or a woman with disability is concerned, then the connotation associated with disability is such that I went to teach disability rights all across India in different universities, and I asked students what they understand by disability. And all said a person who cannot do something, who is unable to do something. So if that's the connotation we all carry, then we have to take certain positive steps. Just mere consciousness may not suffice, because we may still have that unconscious bias. So overtly we may say, oh, we should be supporting them, etc. But when it comes to hiring, we may suffer from an unconscious bias, and therefore to break that and to address that invisibility, I think right now it's essential that we think in terms of how to get more number of people. Not just to increase their representation, but to acknowledge that inclusive equality has a participative dimension as well. We won't be even a human being if we do not participate as a social member of groups, of different groups, which also includes professional groups. So therefore, if we acknowledge that and kind of try to then look at inclusive equality, I think it will make much more sense.
To many more who want to break the paradigm then, and want to make the point that if they have the chance, that they would rather include more people of different abilities. Okay, I want to go around the panel now and talk about, we're here to discuss the 100 years of the practitioner's law. But there are so many laws in the last century that have radically changed things for gender justice, or for for other abilities, for different genders, the same-sex marriage legislations, the Hindu Succession Act changes, Vishaka judgment, for example. I want to go around the panel and get a sense from each of you, if you could choose one law that has radically, according to you, changed things for women and others, not, all the invisibles, if you like. Which would it be? I'm going to start with you, just.
So, you're talking to somebody who has spanned 2 centuries of sorts. We started with almost 2 decades of the previous century when I came on to the legal practice in the 80s. And more than 2 decades of the current century, and things went for a swing for the better. The only thing is, I think it's not just the statute that makes a difference. It is the implementation of that statute, whichever it is and wherever it is, that should make a difference. So we have all these statutes that Suhasini has just mentioned. The point is how much of effective implementation of those statutes have been done by those who are the regulators, the authorities, the enforcers, and ultimately the courts. because whatever goes around ultimately lands up at our door at some stage or the other, whether to test the constitutionality of a provision, or the legality of a provision, or the enforceability of a provision. So these, however many statutes one may have, and whatever the legislators may do, unless the consciousness comes from within, from downwards to upwards and not from up to down, it shouldn't have that pattern of coming as a waterfall. It should come from the basic society, from the community, and go up. People in the community may not know about the statute, but if it is coming from within, they'll be compliant without a statute too. To my mind, the challenge is to make those statutes which are existing work. And if they work to the hilt as they are meant to work, perhaps half the battle would be won. The trouble is that they're there on the rule book. Half of the people don't know about it. Take the sexual harassment at the workplace enactment. Half the people don't know that an IC has to be composed of a particular set of persons. Who's qualified to become a member of an IC, who's not? What are the limits of an IC? Those are things many people don't know. We are talking of something like the legal fraternity. Even within the legal fraternity, there are people who don't know where to go and file a complaint, whether it is to be with the Bar Association or the Bar Council. Now that is the extent of ignorance. So it's more important for us to know how to get the enactment going than to assess the enactment for what it may have done had it been given an effective implementation. That is my call.
Certainly, and you go through the advocacy, the legislators, the bar, the bench, each person has their own path and agenda. Do you want to have a stab at your favorite act or judgment that changed things for women?
I think the core is Article 15(1) of the Constitution, which says that the state shall not discriminate on the ground of sex. And that has been the founding principle for all of these new legislations and the landmark judgments of the Supreme Court and the High Courts. And I think that has been the kind of basis for many judgments protecting women's rights. And so therefore, I mean, it's how do we ensure that we internalize this value of the Constitution, that ultimately the Constitution seeks non-discrimination on the ground of sex, and many other constitutions at that time didn't guarantee that for women. And ours was one of those progressive constitutions which did that, and for me that still is
I'll take a jab at that. So Article 15, as Jenna said, is the group norm, and that is what allows special laws to be made for women. So, okay, so merit is a thing, and to my mind, all women are as meritorious as men. I don't think any woman is less meritorious than a man in the same setting. So things like privileges like education, family, whoever has it, whether it's a man or a woman, is a person who develops similar competencies. So, but that's not the hurdle. The hurdle is the opportunity. How do you get into the room? So that hurdle is psychological, it's social, it's historical. And we cannot overlook that hurdle. And therefore, the provision of Article 15, which says that special laws can be made for women, notwithstanding the equality clause, and therefore they will not be struck down on the basis of equality clause, is the very foundation for women to be let into the room. If you are not let into the room, what can you prove? You can't prove anything. So, and again, I support reservation because I feel that our society, whether it's Indian society or global society, has not reached even a level of equity, of equality in professional areas or economic areas or social areas. So to get to that level of equity itself is a very, very long journey. And since we are celebrating 100 years, what have been our milestones? 1923, 1930, when we had the Roundtable Conference in London. And there again, the two women who went for that conference, Sarojini Naidu being one of them, again had the privilege of a very good education, I think at Cambridge itself, alma mater of your college. And they said, we don't want reservation. But where are we now? Do we still have at least 50% women in leadership positions? Women are first rankers when you are at the entry level. Women perform way better than men. But as you go along the path, they all fall off. So what is it that can sustain them? I feel to reserve a seat on the table is what is going to sustain them. And therefore, I feel one of the most, and I'm really looking forward to it, is the Women's Reservation Bill for the parliamentary seats, because I think that will make it, compulsory for those many women to be in the room, to make laws for the rest of us.
Right. Of course, we can have that whole debate also about whether you need to enforce that at the end or at the beginning. Why aren't political parties making sure that 30% of their candidates are women to begin with? Sanchita, they're going with the Constitution. What would you like to do?
Well, I'm very happy going with the Constitution, and I'll just take this opportunity to continue with what Vibha ma'am was speaking about. So, when we look at the numbers, the number of women who are doing commercial matters, or we still have women, taking up judgeship. Earlier, they were none, and we're making progress. All of that is fine, but when we look at just the numbers, not to forget that we're just looking at a section of the population, and we are really ignoring a larger majority section, where the question still is whether women should study a 5-year law course, A, then is litigation good for her, B, and who is asking these questions, the parents, who is deciding for them, the family, the society, their relatives. So I think the institutional relationship also needs to be acknowledged and addressed each time we talk about women in the legal profession. So when I interact with students, for example, I come across women students say that I am not even being allowed to do internship in Delhi. Women students, parents have asked me who don't come from metropolitan cities that should I let her join litigation, right? So these are the issues that we still come across, and we as a society need to think how to address these issues at the inception, how to make education inclusive at the inception, how to ensure that quality education is imparted to students with disabilities, to women students with disabilities, so that they can even think or imagine of studying law in future, so that they can even dream of studying law in future, because mostly even that's not.
That's a very basic issue. Bhumika, the law that you would vote for.
Thank you so much. Quickly before coming to the law, I would just probably like to ask, and this is again following up on what Vibha ma'am and Sanchita ma'am have been saying, which is whether merit is really the way forward. Because I think it is not important to ask whether or not someone is meritorious, but it is more important to ask who decides what merit is. And when we say merit is the way forward, are we giving more power to the gatekeepers who have historically assessed merit with blind spots? And perhaps it is our systemic obsession with merit why we are this slow in progressing. And a lot of this merit depends on, as Vibha ma'am mentioned, on the socio-economic capital that someone has grown up with, the education, the resources they had. And maybe we do need perhaps quotas, and it is very courageous of me to disagree with Justice Kohli on the panel. But I do believe that we do need quotas for people who cannot be assessed at the same level of the meritorious criteria that we have. And that brings me to the importance of socio-economic capital, and that's where my favorite law comes from. I think the law that has changed everything for the women in this country, perhaps in my opinion, in my humble opinion, is the 2005 amendment to the Hindu Succession Act, which granted the right to women to inherit property. And I think when we talk about freedom, it is the financial freedom that comes first, because if you don't have money in your pocket, there is nothing, absolutely nothing you can do. And I think that is my answer. So thank you so much.
Extremely important. So we have time for one more question, which I do want to go around to the panel with. And of course, we can keep talking about the laws and whether they should reflect today's reality, society's mores today, or should they be more progressive than society actually is at that time. But my real question is about the next 100 years. When we be, none of us will be around, but there will be people talking about 200 years since the Practitioners Act was passed, and maybe very disbelieving that it needed to be passed at all. I want to ask how each of you thinks we can change the system so that the next 100 years don't need to see a film called Invisibles to talk about the fact that there is still so much disparity between the genders and between the others who aren't as able. So very quickly, whether it's more representation, more women, more others in the field, is it the enforcement of more modernization or modern or progressive ways of thinking? Is it about technology? And if I could start with you, Justice Kohli, what do you think the next 100 years really means?
I think it's all a question of change of minds. Yeah, it is working. It's a question of the change of mind of those within the family, because that's the first place where a woman has to thrive and assert herself and insist that she wants to go a particular way. It could be a profession. Well, she could even want to get married and settled. What's wrong with that? But what she wants is important, and what she wants must be respected. So the first thing, and I think that must be a focus, is the family, the extended family, the community as a whole. If they accept what a woman wants and they respect it, then the way is easier. It cuts short all those long routes, that arduous routes that they have to go through to convince people that what they want is good for them and they'll thrive. That, I think, is the first challenge, and if that is met, maybe at least 1/3 of the battle is won. And the second part is, when we talk of merit, to my mind, merit in the background of all things equal. The moment you say all things equal, then you know that you're factoring in some things which may not be equal and need not be considered. For a woman, take for example a simple thing, an elevation of a woman lawyer to the bench. Now, if you're looking at a criteria of income, then perhaps if all things were equal, her career trajectory would be very different and maybe at par with a male counterpart. But it can't be for various reasons. The number of cases she gets, the nature of cases she gets, kind of jurisdiction in which she's practicing, and so on and so forth. But she must be doing a lot of matters, but not getting that kind of humongous fee that maybe other male counterparts could command. So those are things, if they're factored in, then instead of a quota, those all things equal will, to an extent, cover them and give them that backup, which it somehow is missing sometimes.
So society needs to change the next 100 years before the legal profession can set it up with.
I feel the conception of equality is so dynamic. We have seen it developing over all these years, so I would rather keep it very flexible. Though I do have a vision of how the society would look like, that's something that keeps me going. And that society will be where people with differences are sitting across the room, and there's no need to, even if you're acknowledging it's very normal. It's not something which is seen as distinct enough to be considered, to be made a criteria to make any decision.
I think the future of women in the legal profession includes tackling challenges like technology and climate as well. And with the climate crisis, women are going to be way more disproportionately affected given the heat cycles, given how that affects their personal health, and with the gender health data gap and everything. We would need to restructure the legal work, not just according to the time and the facilities, basic facilities, restroom facilities, harassment policies and all of that, but also around how do we make space for more marginalized communities, disabled people, to enable them to actually do work and make the legal profession welcoming for everyone. And when it comes to technology, I'm sure like Sanchita would have had loads of experience with that as well, of how can we empower people with the help of technology. And Vibha ma'am has also previously written about why we need video conferencing in the courtrooms. And that would allow women to work from home and also just be more engaged while they are tackling the social context of law, which is the responsibilities of household chores, mothering, and so many things. So, yeah, I think that's where the potential lies.
I think the attitudinal shift is the key. Women can work from home, or persons with disabilities can work from home only when there's an attitudinal shift of people at the top, as well as colleagues. For me, I was fortunate to have got bosses who were extremely accommodative, and that's why I'm sitting here today. But my colleagues were not, and I was being taunted at, and all of these were my daily experiences, and some of which are enough to throw a person out of the system.
I have to say, on the subject of video conferencing, us journalists are thrilled. It's pure gold, you know, to be able to get that peek into watching, of course, not all the reels and, you know, when we see a judge admonishing a lawyer and, you know, a lot of people get thrills out of that. But really, as a journalist, I think it's opened our eyes. Jenna, what would you say for the next 100 years, what's needed?
Yeah, so I think for the next 100 years, I mean, we've got women's entry into the law. Now we have to really look at women's leadership in the law and women really being on the top, because that is an area that still has a huge gender gap. And even if we are to look at judges, we have such a huge gap with only, you know, we were discussing the other day with ma'am, there are, I think in the High Court, only 14% of women judges in our High Courts, and in the Supreme Court today, just 3%. And if we, you know, just a little bit, Ginsburg, when she was asked, when will she be happy? She said she would be happy when all 9 are women. And so, you know, how are we even going to get to 50%? And if we want to get to 50%, that really has to be an aim, and we have to work towards that. And, you know, one of the things we were thinking about, and I've kind of discussed this with a few people, is that how do we ensure that in every round of recommendations, when names are sent, there are women's names. Today we have names sent from High Courts, 5 names sent, 10 names sent, not a single woman. I mean, are we saying that there aren't meritorious women lawyers in the bar? And only when you have more women's names sent, and then the next step will be how do we ensure that issues like, for example, income is not seen as a criteria for rejecting a woman's name, because she may not have a certain amount of income, she may not have, you know, we've had cases where we had a situation where 10 names were sent from the Karnataka High Court, and that those 10 names had just one woman. That one woman was rejected, saying that she didn't have enough practice. She started her practice after her 2 children were born and she could get back to her career. And so to say that that is a criteria to not think of her as capable of being a judge, I mean, we have to then tackle these criteria. What are real criteria and what are really not core criteria for deciding on a person's capacity. So how do we ensure entry? What Vibha said, entry has to be mandated, and then look at the criteria in an objective, equal weight so that we ensure that people, that women get in and that women from furthermore marginalized groups, minority religions, castes, disability all get in. And how do we ensure that our criteria enable them to get in and we support and the system is able to support them while they are there.
So more empathy in how the choices are made. Viva, I'm going to leave the last word to you.
So I think I'm a naturally impatient person, and I think everybody here is also getting impatient, so possibly wrap up after I've said my 2 bits. So I feel, so one of the things that I read was that it's going to take 149 years to close this gender gap for Southeast Asian countries, India included. So I don't think we are ready to wait for that. And therefore, attitudinal change, absolutely, at every level, we need this change, but we need an accelerated change, which can come only by laws, by mandatory impositions, and therefore, for choices to be made, keeping the numbers in mind. Let's get to the 50% immediately. Let's not leave it for tomorrow or future. And then, of course, we can get into the debate of merit and, comparative things about men and women. And we'll talk about 100% later.
All right. I only have one quote for all of you before I go, simply because some of what we have discussed has been a little disheartening, simply because we're talking about the challenges people face. But I'm going to revert to more than 100 years ago, to the suffragette movement that Justice Kohli spoke about. And there's a book called The Women's Hour, written by Elaine Weiss, and then eventually there was even a Broadway musical performed on the basis of the book, in which she says, just remember, everything the cause has accomplished, every state that was won, this is in the US, every piece of legislation, every change of heart, and every shift in policy was once considered utterly impossible, until it wasn't. So I'm going to leave it here. But thanks so much for being such a great audience, and thank you to all the panelists. Really, thank you for organizing this.
Thank you so much to the panel thank you so much to the panel for such an enriching discussion. But I would like to emphasize that this is not the end, but the beginning of a crucial conversation. As we have time traveled through 3 centuries of past, present and future, we witnessed Begum Qudsiya Ehsas Rasool, one of the founding mothers of our constitution, spearheading zamindari abolition. We revisited the moment in 1923 when Cornelia Sorabji became the first ever barrister with the right to practice law. And then we went through a tribe of women, like Justice Hima Kohli herself, the voices in the film and the voices on the panel who are still here, trying to make things better for the sisters around them in their own ways, laying down the trails that we are beginning to walk on and the systemic power we are beginning to shift. And finally, we tried to brainstorm some of the challenges we are likely to face in the future and how we could address them, as we understand it from within the scaffolds of our own lived experiences. The panel was by no means representative of the sheer diversity and richness of the voices we have amongst us today, or the ones we are going to have in the future. But our hope remains to reach a day when we are no longer asked, why was there no man on the panel? Just like we rarely notice when the women are absent. We only hope to expand this discussion to bring fresh voices, one issue at a time, hopefully with a creative, critical and intersectional praxis, and we sincerely thank you all for joining us on this journey full of challenges and triumphs, barriers and breakthroughs, and hope and resistance. I would like to request Kashish and Aditya to present the plants, and I would like to thank Justice Hima Kohli for gracing us with her presence and thoughts. Ms. Jayana Kothari for her relentless work, generous support, and thought-provoking reminders of why diversity needs to be meaningful. Ms. Sanchita Iron for championing those who are perhaps the least privileged. And finally, Ms. Viva Datta Batuja, who practices what she preaches when she calls for sisterhood, and who continues to support so many of us with her fierce guidance and mentorship, and without whom this commemoration wouldn't have been possible. And the most important, Ms. Suhasini Haider, for being such a superstar at this event and for so kindly agreeing to give us her time and to lead the discussion. I would also like to thank Kashish for being an excellent colleague and a wonderful friend, the Constitution Club of India and their team for logistic support, our SDR team members, Bani, Kapil, Praveen and Aditya, and our volunteers, Adarsh, Shweta, Daman, Harshita, Komal, Karan, Tejal. As you can see, it takes a tribe to pull this off. And also the tech team and the photographers, Rohit and team as well. And finally, I thank you all for joining us. Tea is now served, and there's a little surprise for the creatives and filmmakers in the audience and the hidden artists if you're a lawyer. We will be playing a 3-minute behind-the-scenes documentary as you all proceed to have tea, which deep dives into the process of making the film, which is also a shout-out to the film production team. So feel free to stick around and watch the joys and pains of putting together the film. Thanks very much once again, and I hope you have a lovely rest of the evening. Thank you so much.
Bhumika for the conceptualization. She's done a wonderful job.
Yes, ma'am.
कैसे लगाने
Or try. So, Lady Justice might be blindfolded, but the man guarding her on.
Last year I did some field work where I interviewed about 25 Indian lawyers, and the film actually came out of what most of the female lawyers ended up talking about, which was how their identities are shaped not just by the law itself but also by the agents, and how the male gaze affects women practicing day to day in courtrooms.
Being a lawyer myself, I have a fair idea of these issues. It was interesting to see that this research has brought out those issues in a much clearer fashion, and also to see new things coming out of this research.
I wanted to make this sort of an evocative audit almost, where if we show the film in law schools, in different spaces, to different lawyers, then they feel what the data is saying.
As an animator, I always wanted to work on projects which have more of a purpose in the subject. I am from India and I wasn't aware about all these circumstances in the legal system. All I hear and see are news articles and updates, and I did not know that the very core needs such shaking.
I didn't thought that there's so much pressure still in 2023 put on women to present themselves in a certain way just to be taken seriously than men are. Law and Indian culture are not something I'm very acquainted with, so that's why I'm really excited to work on it, because it's also a way for me to learn more about these things. It was very intense, but I really enjoyed it.
We need to design everything together, and I drew the storyboard and we designed all the sequence and shooting, so it's very creative. I really like work with Ash, Bhumika and Shubham because everyone has their own specialty, so I can receive different ideas from animation and choreography and photography.
It's just remarkable to imagine that filmmaking is such a tedious process, but such a rewarding process as well.
what are we doing now?